Before I invite oral submissions on the compensation issues which I have identified, it's my sad duty to report that on the 5th of April, Mr. Robert Boyle, a former sub-postmaster and a co-participant, passed away suddenly. On my own behalf and on behalf of the whole inquiry team, I extend my deepest sympathies and condolences to Mr. Boyle's family and friends. Shortly after Mr. Boyle's passing, I received an application from his son Christopher, who is Mr. Boyle's executor, to become a co-participant in the inquiry, and I have granted that application. Mr. Maloney, I understand the position to be, but correct me if I'm wrong, that Mr. Boyle Sr., if I can call him that, received 2 interim payments under the overturned conviction scheme, but his final award had not been finalized prior to his death. Thank you. Right. Well, I have an audience on a scale with which I'm completely unused. So I think, Mr. Chapman, it's for you to begin the oral submissions.
For international trade. Amongst other areas of government work, the Department has taken on those functions relating to the Post Office, which were previously carried on by BEIS. The Department has expressed on a number of occasions its disgust at the Horizon scandal and the awful impact it had on many people's lives. It's important to restate that today. The Department remains fully supportive of the inquiry's vitally important work in establishing the facts of how this appalling situation came about, identify fault, and make recommendations to ensure nothing like it ever happens again. For the purposes of today's hearing, the Department wishes to reiterate that the issue of compensation remains one of its top priorities. Significant progress has been made on this front since the last hearing dealing with compensation matters. In relation to both the historical shortfall scheme, the HSS, and compensation for postmasters with overturned historical convictions, the OHC, the Department continues to devote considerable resources to working with the Post Office to ensure that full awards are provided to all those affected as soon as possible. As you know, the Department itself is directly responsible for the implementation and administration of the Group Litigation Order, or GLO, further compensation scheme. This opened for applications on the 23rd of March of this year. And good which we all recognise is positive news.
I'm trying to think of something appropriate to say, but I simply can't, Mr. Chairman.
And good progress has been made in the first month of its operation. However, the Department recognises that there's clearly much work still to be done. Its position remains one of genuine and open engagement, with the goal of doing whatever it reasonably can now and in future to ensure full and fair compensation as quickly as possible for everyone affected by the Horizon scandal. The inquiry has seen the Department's written submissions for the purposes of this hearing, dated the 6th of April 2023, which are publicly available to read on the inquiry's website. I don't intend to repeat what's set out there, but instead we'll seek to provide further relevant updates and engage with some of the issues raised by the other core participants in their written submissions, in the hope that that will be the most helpful, useful way to spend the allotted time this morning.
Yep.
I'll address these issues under 4 headings relating to the 4 matters upon which you, sir, have requested core participants' input at this hearing. And they are bankruptcy, taxation, an update on the HSS and OHC schemes, and an update on the GLO scheme. Starting with bankruptcy, the department has been clear throughout that its objective is to ensure that all postmasters are put back in the position they would have been in had the Horizon scandal not happened. This applies as much to those who've faced bankruptcy due to Horizon as to all others. The department is determined to do whatever is necessary, whatever it takes, to achieve that aim. We're grateful to the inquiry for commissioning and sharing the careful and detailed written opinion of Catherine Addy KC. Without attempting to explore in any detail the obvious complexities of the issues identified, I will try to provide an update and some reassurance in relation to the 3 points raised by other core participants. First, as noted in our written submissions, there is one insolvency practitioner, more, who so far refused to agree that compensation payments under the GLO scheme do not vest in the bankruptcy estate. The department has already been considering the option of an application to the court for a direction in respect of the 16 cases held by Moore. The department will now see if Catherine Addy's opinion has caused that insolvency practitioner to reconsider its position before making any application to the court. Whatever the outcome, the department will ensure that claimants personally receive full and fair compensation. It shouldn't be necessary for any postmaster to take action themselves under the Insolvency Act and join the department as an interested party, as Howe & Co have suggested in their written submissions. Second,
before we leave that, Mr. Chapman, and it's a theme that will recur, so I might as well get it out in the open now. There's an end point on the GLO of early August next year, yeah? So delays related to, and I use the word delay at the moment without seeking to apportion any blame for delay, simply using it in that way. But delays in relation to issues such as whether Moores are right or Miss Addy and you are right, are likely to be, or are likely to impact upon the timescale that we're all working to, yeah?
yes.
And Miss Addy's advice has been in the public domain for many weeks now. And I would have hoped that a swifter resolution of this could have been achieved, in the sense that either Moores, putting it bluntly, say, okay, you were right, or someone does something to prove that you were right.
Yep. Well, I'll address that head on. The department understands the point, and if it realises that time is of the essence, and as a result of that, it is going to press more for an answer, and if the answer is not satisfactory, then it will take appropriate steps. In relation to the delay, and I'll turn to that to the end point of the GLO scheme, and I'll turn to that to address it more fully in due course. The department is conscious that under the Appropriation Act, which provides the statutory basis for the GLO scheme, there is a defined endpoint, and it has to work towards that. At the same time, as I've already indicated, the department is keen to observe its objective, that nothing should get in the way of full and fair compensation as swiftly as possible. I was going to turn, sir, to my to the second of the points raised by the core participants and to address that. That relates to the suggestion made by Howe & Co. that the department has been, to quote, holding bankruptcy cases at the back of the queue. That is not correct. The department recognises the very difficult circumstances of bankrupts and that there's often a particularly urgent need for resolution in their cases. However, what is absolutely clear is that the issues are complex, and those have inevitably taken time to work through and a great deal of effort to work through. And as just discussed, some of those issues are ongoing and are still being worked through. It's not possible for the department to avoid or sidestep those complexities, and indeed doing so, had it attempted to do so, might simply store up issues for further down the line. All bankrupts have now received GLO interim payments, except for one who has recently applied, or only recently applied. Third, Howe & Co. have suggested that the department should provide further detail on how certain bankruptcy cases will be dealt with within the GLO scheme, and have asserted that the current scheme doesn't give sufficient protection to those made bankrupt through annulment or rescission applications, or those who've been required to enter IVAs. The department actively encourages those who wish to seek an annulment or rescission to do so, and will cover their reasonable legal fees. Howe & Co. have also proposed that the department prepare a schedule of potential cases or situations where damages would not be recoverable by the insolvency practitioner. As set out in the department's written submissions, all but one relevant insolvency practitioner, and that one being Moore, has signed a waiver to the effect that it is agreed GLO interim and final payments don't vest in the bankruptcy estate. Given this, it's unlikely to be necessary, in the department's estimation, for further detail on specific cases to be provided. But, and this is a sort of golden thread running through the department's position, it remains in listening mode and it will keep this under review. Can I turn then to taxation?
Well, can I, again, just for clarity's sake, and so that I'm not minimizing what's going on here, the point of principle in the GLO relates to more. All other issues, to a greater or lesser extent, are issues of assessment and practicalities. Yeah?
Yes.
Right, thank you.
Taxation. As set out in our written submissions, compensation payments under the OHC and the GLO schemes have been exempted from tax. Payments to HSS claimants have not been. The HSS was set up primarily to put postmasters back into the financial position they would have been in had they not had to repay shortfalls, as well as reflecting any non-financial losses that they may have suffered. In a similar way to commercial compensation schemes, awards are calculated on a gross basis, with tax then payable on amounts relating to what would have been taxable income in the year it's received. Now, for the OHC and GLO, where an exemption is now in place, awards are calculated on a net basis, and then no tax is due on the final amount. In respect of financial losses, all of the post office compensation schemes aim to compensate the postmaster for the actual net amount that would have been received.
You're going to have to educate me, and Ms. Gallifant may have something to say about this as well. But my understanding is that in terms of computing the loss, both under under HSS and the other two schemes, those administering the scheme adopt what I might call the conventional approach to computing damages. So in other words, if there is a claim for loss of wages, the loss of wages paid to the particular applicant is the loss of wages net of tax. That would be what would happen in a court, wouldn't it?
Yes.
I'm assuming that this is what's going on. You may tell me that's not what's going on, all right? Therefore, I am struggling to understand the distinction that is being drawn between the two schemes on the one hand and HSS on the other.
Can I perhaps cut to the chase in this way? That the HSS system was set up without recognition or without full recognition of the potential tax consequences that may flow from it, and it may well be that Ms. Gallifant can also expand upon this, because this is
nothing like bug passing, is it?
I want to ensure that the inquiry fully understands the position.
Yeah.
Now, at the time that the HSS was set up, and as you know, and as we've discussed at previous compensation hearings, it was set up on the assumption, an assumption which turned out to be incorrect, that a relatively small number of applications would be made, and that relatively small number of applications would be to a relatively small value.
Yeah.
That has proved not to be the case, but that assumption has affected the way in which the taxation consequences were understood. Now, the department recognises that because of that, there is potential unfairness to those within the HSS of a non-exemption for tax. And it has looked, together with HMRC and the Treasury, at the possibility of exempting payments within the HSS from tax in the same way as the other scheme. The problem, and that is a suggestion that you yourself made, sir, in a previous hearing. The essential problem with that is that a large number of payments have already been made. And in order to, if those payments were retrospectively to be exempted from tax, it would place the recipients of those payments in a substantially advantageous position as compared to recipients of payments under the other schemes. As is clear, as I've made clear previously, and as I'll go on to make clear, one of the department's objectives is to ensure reasonable parity as between the different schemes. What the department is obviously keen to avoid is a situation where where an exemption for the HSS payments is put into effect, because that would, in order to achieve parity, involve retrospectively recalculating the payments, and in some cases, in order to ensure parity, potentially seeking to recoup some of the payments, and that is something that, for obvious reasons, it wishes to avoid. But it does have, HMG, the government, does have a solution to this. The government will support the Post Office with funding to make additional payments to postmasters in the historical shortfall scheme to ensure that compensation is not unduly lost to tax. So there are various ways of skinning the cat, but the government, the department, has concluded that that is the best, in practice, the best way of doing it. The implementation of these payments is complex, and the department will announce further details as soon as possible. But the outcome of that will be that that recipients of compensation under the historical shortfall scheme are in exactly the same position in relation to tax as recipients of payment under the other schemes where tax is exempted.
Well, speaking, obviously having heard what you said for the first time, speaking, therefore, to an extent without having thought it through, it's obviously highly desirable that parity is achieved in this way. And I don't suppose that would be controversial by any right-thinking person. My concern is simply to ensure that the department actually tells us what it's going to do, and I'm not trying to be unduly difficult, but sooner rather than later.
Yes.
Because these things are taking time, Mr. Chapman.
The department gets that. It understands that loud and clear.
All right. So I was going to ask you and Ms. Gallifant to give me a tutorial in the assessment of damages and the impact of tax upon it. But am I now to understand that that is unnecessary because one way or another, every applicant to whichever scheme will in the end be treated in the same way? In practice.
In practice. In outcome, yes.
In outcome, yeah, which is what presumably they're concerned about.
That's what matters so far as the department is concerned, yes.
Well, then we'll defer the tutorial unless Ms. Gallifant disagrees with what you've had to say.
Can I turn to tax advice and the cost of tax advice?
Yes.
Because a question's been raised by Howe & Co in their written submissions as to whether £1,000 is sufficient in legal costs to get adequate tax advice for postmasters claiming under the GLO scheme. Given that GLO payments have been exempted from tax, the department expects that £1,000 will be sufficient in many or most cases. But as Howe & Co are aware, the rates for legal costs were agreed by the department with them and other claimants' representatives. And this includes a process for approving financial support for further expert advice, which might include tax advice, where needed in addition or on top of the £1,000. So £1,000 is not a fixed, set in stone upper limit. Turning briefly to progress on the HSS and OHC. As you know, the department does not have direct day-to-day responsibility for these. And this is not intended to be an example of buck passing. The post office, Ms. Gallifant, will obviously be better placed to provide details. We're pleased to note, however, the acknowledgement by, for example, Hudgell solicitors that there has been encouraging progress, and we endorse that. We also make the following higher-level comments. First, in relation to the HSS, we welcome the substantial progress that's been made, with over 99% of applicants having received first offers, and the remaining 23 cases waiting on information from third parties. Late applications are being accepted without any requirement to justify or explain lateness, which is news with which the department is very pleased. We're also pleased that there's been a very high rate of acceptance of offers. Second, in relation to OHC compensation, Interim payments continue to be made promptly, and the early neutral evaluation has led to offers of non-pecuniary damages being made in 67 of the 69 claims which have been submitted to date. The Department welcomes the Post Office's proposal to move to a remediation process for pecuniary damages, which should allow full and final settlement to be reached more quickly than would otherwise have been the case. And then turning to progress on the GLO scheme. The Department has been working as fast as it can and has devoted substantial resources to this process to set up the GLO scheme since announcing it last year. The Department has asked me to express its condolences on the death of Isabella Wall and its regret that it was unable to get the GLO scheme up and running in time for her to receive final compensation before her sad death. The scheme opened last month, and so far some 377 registration forms have been received. 90% of the claimants are already legally represented. I'm going to deal with 6 issues about the scheme which have been raised by other core participants and indeed in the media. First, there have been concerns raised about the timeline for the scheme. The Department's powers under the Appropriation Act to make payments run out in August 2024. Howe & Co have called for the Department to extend this deadline. That is not within the Department's gift. The use of the Appropriation Act for these purposes is restricted by Parliament. But as I've already indicated, the Department is determined to meet the deadline and indeed complete the scheme well before that date. It's recently appointed Dentons as claim facilitators, and they are currently undertaking a planning exercise. The intention is to agree with all parties, including claimant solicitors, a detailed timetable for the scheme, which will assure its timely completion, with all claimants having been given a proper opportunity to apply and to consider offers. The progress of delivery against that timetable will be publicly reported.
Well, I can't express my anxieties about this timeline too strongly. Anxieties in the sense of, just to put it in terms I think we can all understand, you will have upwards of 400 people, no doubt, by the end, who are making applications under this scheme. And you have approximately 14 months or thereabouts, 15 months, in order to achieve your objective. And again, without wishing to attribute blame for this, albeit with much greater numbers, HSS is now roughly 3 years old and counting. So you understand why I'm concerned.
The Department hears that. I do emphasise again the Department's commitment to doing what it reasonably can, doing everything it reasonably can to ensure full and fair compensation. Second, in relation to timing, a particular concern has been raised by Freeths and others about the pace of disclosures by the Post Office. It's important to emphasise that there is no issue about meeting the costs of disclosure. The Department is of the view that these disclosures are vital and that they will be delivered. The constraint on pace is the size of the task, the difficulties faced by the Post Office in locating historical records, and critically, the availability of resources, and that means, in this case, individuals with the right background and experience to ensure that the disclosure process is completed fully and properly. This is plainly a very significant task requiring staff who understand the complexities of the accounting records. An estimate of 32 weeks was initially suggested for the completion of the task, but since that estimate was made, the Post Office have brought in additional resources from elsewhere in the business to accelerate the work, and the department is aware that the Post Office is currently developing a revised estimate. It's also important to note that the 32, or the initial 32-week estimate, was for all disclosure to be completed, and in practice, documents will be produced on a rolling basis progressively over that period. The department is aware that the Post Office will mitigate the effects of the process on the overall timeline for the scheme by prioritising disclosures for the most difficult cases as identified by claimant solicitors. The department will also ensure that no applicants are prejudiced by lack of documents held by the Post Office. The GLO scheme guidance states that although it is in your interest that your claim is well evidenced and quantified in respect of each head of loss, the scheme recognises that this may not always be possible given the circumstances and length of time which has passed, and that there will be an absence of evidence. As such, DBT will take a proportionate and considerate approach to the availability of evidence. Third, on the theme of documents and evidence, Freeths have questioned whether expert input will be allowed, such as from medical or forensic accountancy experts, where required. As part of the tariff which was agreed with claimants' lawyers, the department has agreed to consider requests to fund the provision of expert evidence. And where such applications are approved, claimants' lawyers will be authorised to commit costs of up to £7,000 for advice from a forensic accountant and £3,000 for advice from a medical expert. And the department will consider applications for further costs in more complex cases. The department recognises that expert evidence will be required in many cases. However, its goal is to maximise the proportion of expenditure on the GLO scheme which goes to postmasters rather than to the costs of processing awards. It's important to explain here that what I'm talking about is a proportion. There is no arbitrary pot of money for the GLO scheme. In effect, it costs what it costs. The department will, as the guidance says, take a proportionate and considerate approach to the availability of evidence. And so in less complex or severe cases, expert evidence should not be necessary because the claimant's factual evidence, such as GP records, will be held to be sufficient. The department is concerned that claimants' lawyers will assume expert evidence is needed in too many cases where that is not necessary, and that in turn will lead to unnecessary complexity and delay. And for that reason, it does reserve the right to challenge claimants' lawyers on the point, but it will do so promptly where that's appropriate. So far, responses to all applications have been given within 15 days. Fourth, questions have been raised about the banded approach to compensation for stigma or reputational damage, and indeed for some other heads of loss. This seems to be based on the misperception that the bands represent or constitute an upper limit. They don't. They're based on awards made by the independent panel for the HSS, based on well-established legal precedents. and the department has yet to see precedents which are demonstrably inconsistent with the guidance given. But at the Minister's request, the Advisory Board has considered the issue. It comprises Professor Richard Moorhead, Professor Christopher Hodgson, Lord Arbuthnot, and the Right Honourable Kevin Jones MP. And they together have proposed that the GLO scheme's principles and guidance be revised to make clear the following. First, the bans are not maximum limits or a cap, but indicative guidance for claimants, their lawyers, and the independent panel. Second, that each case will of course be decided on its merits, and it's expected that there will be cases where the facts demand awards higher, indeed sometimes significantly higher, than the upper figure for the top band. Third, if a claimant's compensation cannot be agreed through the alternative dispute resolution process, claimants have the right to have it considered by the independent panel, which includes a KC and other experts. And fourth, that the independent panel will look at the whole of each case in the round and be guided by overall considerations of fairness. So that was the Advisory Board's proposal. It intends to hold discussions with members of the HSS independent panel in order to confirm the way in which their figures were devised and used, so as to encourage greater transparency and consistency about these matters. And in a written statement to Parliament yesterday, the Minister has publicly accepted the Board's proposal, and amendments to the principles and guidance will be published as soon as possible. Fifth, concerns have been raised, particularly by Howe & Co, about the extent to which the Department has consulted with claimants' lawyers in the design of the scheme, and various criticisms are levelled at the design of the scheme on that footing. The Department wishes to make the position very clear and to do so publicly. In fact, the Department has engaged extensively with Howe & Co and other solicitors representing claimants in the course of designing and developing the GLO scheme. This has included circulating the initial draft of the scheme principles on the 7th of November last year and discussing comments from postmasters solicitors at a meeting on the 14th of November last year. Publishing a further version of the draft scheme principles on the Department's website for consultation on the 7th of December last year, informing postmasters solicitors on the 26th of January this year of the Department's initial proposals on the sequence of actions under the scheme, the claim and registration forms, and the data which would be disclosed by the Post Office. This was then discussed at a further roundtable meeting on the 27th of January this year. Engaging in a mediation process involving several meetings and exchanges of documents, which led to agreement of the tariff of reasonable legal costs. Providing a further draft of the scheme guidance and principles together with a supporting Q&A document for claimants on the 20th of February this year for comment. Providing a near final draft of the scheme guidance and principles, including the proposed bandings for stigma and other issues, on the 14th of March. And providing a draft of the application form, claims overview form, and claimant journey process map on the 3rd of March for comment. The Department therefore does not accept the assertion that the Department failed to consult with claimant solicitors. The Department notes that both Freeths and Hudgels make the more specific comment that they did not feel there was sufficient opportunity for claimant solicitors to engage with the compensation bans and the tariff for stigma damages in particular. Freeths, as part of their contract with the Department, were asked to identify and give anonymised details of moderate, serious and severe cases which could serve as benchmarks for the GLO scheme. The Department's lawyers developed an upper and lower figure for those cases described for each band based on awards made to claimants by the independent panel for the HSS. Given the pace at which the scheme has been developed. The department regrets that although it shared the banding information in advance of publication, there was insufficient time to consult claimants' lawyers on the figures attached to each band. But it's confident that the figures are consistent with established legal principles, and the advisory board is continuing to review the evidence in this area. As I've already said, amendments to the principles and guidance will be published soon to clarify the approach being taken. And in any event, the bands represent, in effect, guidance rather than caps. Sixth, Freeths have also raised a point about whether there is an unduly narrow definition in the scheme's guidance and principles documents about causation, where the wording horizon shortfall is used rather than the horizon issue wording that Freeths has suggested. The department recognises that the High Court's judgments deal with issues of the Post Office's conduct and contracts, as well as the false shortfalls generated by the Horizon system. And in light of concerns about this issue expressed by Freeths, the department inserted in paragraph 1.3.4 of the scheme's principles and guidance a reference to the findings of the common issues and Horizon issues judgments. It believes that this reference should be sufficient to enable it to address the concerns which Freeths have raised. It has asked that if losses are found which cannot be dealt with under the existing text, it should be notified as soon as possible so that it can assess whether and how the principles should be changed. But its view in substance is that the text of the text that's been adopted should not restrict suitable awards of compensation. Finally, a brief comment on the case of Nicola Arch, who I know is here in the hearing today. Whilst the department generally steers away from dealing with individual cases in submissions to the inquiry on compensation issues, HJA have suggested that her case was only accepted into the GLO scheme following a detailed objection from Paul Marshall. That is not a correct analysis of the position. As the inquiry has noted, evidence of events over 20 years ago can sometimes be hard to come by. The department has pursued all opportunities to seek out such evidence so that postmasters can be fully compensated. Where post office records are insufficient, it is sometimes necessary to ask the postmaster themselves if he or she has any evidence, because it's known that some of them do have relevant documents. However, that's not necessarily, and in all cases, the only source of further evidence. It would be unfair on other postmasters if the department did not take a consistent approach across every case. And in fact, the department did find sufficient evidence from other sources to satisfy itself of the nature of the prosecution of Miss Arch, and an interim payment has been made. The department is grateful to Miss Arch for liaising with it and for her patience as it's worked to increase her interim compensation for the distress and hardship that she's experienced over so many years. I conclude with a brief word about what the department's doing to ensure consistency across the three schemes. The existence of three separate streams of compensation reflects the complex history of the Horizon scandal and the way it's developed over time. The department already had extensive measures in place to ensure that postmasters in similar situations were given similar treatment, regardless of the particular scheme under which they fell. It has now created an internal programme board to provide additional assurance. and it's extended the remit of the GLO Advisory Board to include the Department's supervision of the schemes delivered by the Post Office. All three schemes have come a long way since the inquiry reviewed them in July last year, and indeed in December. When attempting to deliver a complex programme at pace, some issues will inevitably emerge, and the Department remains in listening mode. But the extent of progress should at the same time be recognised. The Department remains committed to ensuring that all postmasters affected by Horizon get full and fair compensation, and they get it as promptly as possible. The Department continues to stand ready to assist the inquiry however it can, and in particular to provide further updates on the progress of the compensation schemes, if that would be helpful in due course. Thank you, sir.
Thank you, Mr. Chapman. Do you want a short break, or are you happy to start straight away, Ms. Gallifan?
Happy to start straight away, sir.
Fine.
Thank you.
Let me adjust myself so that the pillar doesn't...
I know, I'm sorry, I might lean either side. Apologies to all.
Yeah.
Thank you. So we are grateful for the opportunity to update the inquiry on developments in relation to compensation since the last hearing on this matter in December last year. Before doing so, Post Office wishes to offer its most sincere condolences and sympathies in respect of the passing of Mr. Robert Boyle. We wrote to the inquiry in this respect on the 20th of April last week, copying in his solicitors, confirming the position in relation to compensation, which we hope was of assistance. In advance of this hearing, we provided written submissions on compensation dated the 6th of April, addressing the 4 particular topics on which you invited core participants to address you. I'm conscious that you will already have had the opportunity to read those submissions, and they've been published on the inquiry website together with these submissions from other core participants. I'm also very conscious you've just heard from the Department on a number of the same points as were set out in Post Office's submissions. In these circumstances, you may be grateful to know I don't intend to go through every aspect of our written submissions, but to flag the key points from the perspective of Post Office and to seek to respond to a number of matters that have been raised on behalf of the Postmaster core participants in their written submissions. Before I turn to those matters, I'd like to explain my use of certain terminology today. To date, the scheme established pursuant to the Group Litigation Settlement Deed has been known as the Historical Shortfall Scheme, or HSS. Similarly, the mechanism by which those with overturned convictions can obtain damages for malicious prosecution has been known as the Overturned Historical Convictions, or OHC. In the past few months, Post Office has received feedback that some postmasters consider that the use of the term historical is inappropriate and offensive in this context, as it suggests that the suffering of postmasters affected by the Horizon scandal is in the past. Post Office wishes to make it absolutely clear that this was never its intention, and it deeply regrets any further distress caused to any postmaster as a result of its use of that term in this context. Having heard the depth of feeling on the part of some postmasters, Post Office will now be taking steps to change the terminology used. So for the purposes of today only, I will be referring to the shortfall scheme and to overturned convictions. And in due course, Post Office will consider how best to change the names of those schemes. If any postmaster wishes to raise any other concerns or queries about Post Office's use of terminology in relation to compensation or indeed otherwise, then Post Office would welcome their views. Taking each of the topics in turn, I start, of course, with the issue of bankruptcy. With the shortfall scheme at the outset of my submissions, can I put the issue into context? Out of 2,417 applications to the shortfall scheme prior to June 2022, there are 63 cases in which it's been determined that the cause of action vests in the trustee in bankruptcy, 2 in which it's determined it vests in the IVA supervisor, and 2 in which that question is still being clarified. In relation to 263 applications, which have been received since June 2022, sometimes referred to as the late applications, there are 27 cases in which a potential issue due to bankruptcy or an IVA has been identified. Of those, there are, 27 cases. Of those, there are 6 in which it's been determined that the cause of action vests in the trustee in bankruptcy, and the remaining cases are yet to be determined. Now, starting with causes of action and entitlement to damages, with respect to the vesting of causes of action and entitlement, Post Office broadly agrees with paragraphs 34 to 36 of Catherine Addy KC's opinion. At paragraph 10 of our written submissions, we've set out Post Office's approach in practice on making offers and apportionment of damages between the trustee and the individual. We would emphasise that to date there has been close engagement and cooperation with the official receiver with regard to the apportionment of losses in order to ensure that payment is being received by the appropriate party who has the right to recover damages. Bankruptcy cases in which the trustee has an interest are intended to be settled through a tripartite settlement agreement by which all parties agree the release of causes of action on the basis of the agreed apportionment of the damages between the trustee and the individual. And any surplus from bankruptcy estate is then returned to the individual. Now, individuals are encouraged to take legal advice paid for by the Post Office on this issue, and they can also, of course, dispute the proposed apportionment if they wish to do so. But as yet, Post Office are not aware of any such dispute having occurred in terms of apportionment.
And are most of those people, if not all of them, taking legal advice, Ms. Caliphant, as far as you know?
I believe so, but I'll be corrected otherwise if I'm wrong on that. But it's an offer made to all of them. Yeah. Post Office considers that the approach it's taken to compensation offers relating to bankruptcies so far in relation to the shortfall scheme represents a fair outcome consistent with the legal rights of the parties. The position is, of course, slightly different when it comes to bankruptcies caused by horizon shortfalls. Now there, the independent advisory panel considers each case on its merits, as it does with all cases, having regard not only to the complex legal principles involved in relation to bankruptcy, but of course the overriding objective ensuring offers are full and fair. In considering this, it makes no difference whether Post Office was the petitioning creditor or whether the postmaster applied for their own bankruptcy or whether another organisation petitioned for it. The panel considers and makes recommendations on all cases following the same principles. In such a case, the panel assesses the heads of loss on broadly similar principles to those set out in Catherine Addy KC's opinion, in respect of the award of general damages, consequential financial losses, diminution in value to the bankruptcy estate, other costs, fees and expenses incurred, and consideration in particular in each case of the question of the postmaster applying to annul the bankruptcy order and the Post Office offers to pay the legal costs of any such application. Moreover, Post Office has waived its right to claim any dividend in the bankruptcy and or repay any dividend that may have previously been received. In addition, the panel has sought to compensate individuals for the malicious institution of bankruptcy proceedings and or an abuse of process where that's applicable in an individual case. And we've used Lord Dyson's findings in the early neutral evaluation, as well as damages awarded in cases in the shortfall scheme involving criminal prosecution but no conviction, to inform the level of damages in that context. We note the concern raised by Hudgell's solicitors in their written submissions, paragraph 12, that there appears to be, in their view, a change of approach to the assessment of the awards of general damages by Post Office. We'd like to reassure postmasters the panel has applied the same principles throughout to each and every claim. It may appear that higher offers are being made in the later stages of the process, but we'd ask you to note, sir, as we anticipated, this is the result of more complex claims being assessed, not because there's been a change of approach in principle by the panel. Each case is determined individually on its own legal merits according to the applicable legal principles. I also note that where the panel considers and determines that the bankruptcy was due to horizon-related shortfalls, it will consider an award of stigma attached to the bankruptcy. We note the request for earlier offers where bankruptcy has been an issue to be revisited, but as the principles have been applied consistently, we don't consider that that's required unless we receive further information from applicants. If further evidence is produced which goes to the issue of whether a horizon shortfall loss was the cause of a bankruptcy, then Post Office will consider the issue of causation taking into account that evidence. This is the approach that Post Office has always adopted, and it's reiterated this approach in correspondence recently with Dr. Hudgell. Post Office is paying for legal advice for applicants on the offer and its allocation between the trustee and the individual, as I've mentioned. And similar principles to those I've just set out are applied to IVAs.
So can I take it that the 63 cases that you referred to in which bankruptcy is an issue is a figure relating to those outstanding cases, those cases which are outstanding, I should say, and that there are more cases than 63 which may have been dealt with by an award which has been accepted. Have I got that right?
No, it's that there were 63.
So 63 is the total?
Is the total figure.
Right.
Yes, and
63 is the total.
Yes.
But some of them may have been resolved.
Exactly. And I'll come on to that when I update you on the scheme more generally, but yes.
Right.
Yes, that's the total. There aren't more. There are only two.
That's what I was worried about. Yeah.
Yes, two still remaining to be clarified, but other than that, there are 65, 63 with the official receiver, trustee in bankruptcy.
So that I'm absolutely clear, of the 2,400 plus cases which were received in time, if I can put it in that way,
yes,
there were a total of 63 cases which involved bankruptcy.
Possibly 65. Two
Sorry,
yet to be determined. So
there were a total of 63 cases determined to be involving bankruptcy, 2 cases involving IVA, and 2 which are in the process of being determined.
Exactly.
Right.
That's exactly right, sir.
Right.
Thank you.
Sorry to have taken you out of your thread, but I want to be clear about that.
That's absolutely fine, of course. Now, just dealing with one short point in relation to the assessment of damages, where there's a causal link between Post Office's conduct and the bankruptcy. It is Post Office's view that a full and fair award has been determined in each case within the shortfall scheme, having regard to the individual circumstances. But there is one aspect where Post Office does differ with the opinion of Catherine Addy KC, which is paragraph 49, Little Roman 2, which is in relation to the relevance of the jury damages awarded to one Major Wilson. And that was for loss of credit and reputation in a case that dates from 1920. Now, the principles derived from that case have been taken into account by the Independent Advisory Panel in all of their assessments. But we do say that Major Wilson's circumstances were rather uncommon and personal to him, and it's Post Office's view that it would be inappropriate to use his award as a yardstick for postmasters generally. The important thing we say in every case is that the Independent Advisory Panel aims to achieve each postmaster having their case assessed on its own merits in a way that is personal to them in accordance with applicable legal principles. But I simply put that down as a marker, it being flagged up by some other core participants.
And so that people can understand my role in all this, there is an internal mechanism within HSS for resolving disputes.
Absolutely.
And ultimately, someone might push that point as far as it will go, so to speak.
Indeed,
and it will be resolved.
Exactly. That's exactly right.
But I cannot resolve it.
No, and we're certainly not inviting you to, sir. It's more a question of expectation management than anything else, and we felt it right to be clear on that small point, but potentially important, of course, for individual postmasters who may have read or been reported to the outcome of the Catherine Addy opinion, just to make it clear that that's one point on which Post Office does diverge slightly, but absolutely it's a matter which, were it to be taken, could be resolved in accordance with the dispute resolution procedure. Thank you. Can I just deal with then briefly the practical approach to applications for annulment or rescission of bankruptcy? Again, the Post Office seeks to engage with the applicant in good faith regarding the potential to make such an application, should they wish to do so, and it will cover their reasonable costs associated with it, both to the costs incurred by the applicant and by an insolvency practitioner, both in respect of the decision to apply and the application themselves, were they to make it. We note the submissions and the request made by Howe & Co. paragraphs 58 to 61 of their written submissions, for a list of all cases where Post Office secured bankruptcies of postmasters as the petitioning creditor. And they seek witness statements from Post Office confirming those orders shouldn't have been made. So the short point is, Post Office is already communicating with postmasters about bankruptcies which should not have been pursued due to Horizon-related shortfalls, where the Post Office was the petitioning creditor. And it is already taking all practical steps to assist the postmaster in annulling such bankruptcies within a reasonable time. In those circumstances, quite apart from the data protection issues that would arise from any proposal to provide such a list to all solicitors' firms, we consider it would not take matters further to provide the information suggested. So you may want to note, going back to your earlier query, of the applications accepted into the shortfall scheme prior to June 22, the in-time applications, if they put like that, Post Office has identified 27 applications where a causal link exists between Horizon shortfalls and bankruptcy, and it's made offers in all of those 27 cases. So far as applications that were accepted after June 2022, Post Office is yet to determine the total number of applications in which a bankruptcy or personal insolvency has been caused by Horizon shortfalls, but work considers apace on those applications. Post Office hasn't yet, of course, made then any offers in respect of those applications. We reiterate, these figures are not static. Issues can arise. They're resolved as the circumstances develop in each case. We're, of course, very happy to continue to update the inquiry as regularly as it would wish to on the numbers involved. In respect of personal causes of action that clearly vest in individuals or where they otherwise have a right to recover damages, Post Office is currently looking to make interim payments to those postmasters who went through bankruptcy by reference to any personal injury and or distress and inconvenience that they've suffered and for which they should be compensated. We note and agree with the indication in the written submissions of Hudgell solicitors that the bankruptcy issue in respect of shortfall cases is more complex than in relation to overturned convictions. We equally welcome their view that some encouraging progress is being made in this respect. We also note the concerns raised by Howe & Co, paragraphs 76 and 105 to 109 of their written submissions, regarding procedural delays in relation to one of their clients in the shortfall scheme. Post Office wishes to apologise for the delay that's occurred, wishes to reassure you and her representatives that a letter will be sent to her within the next fortnight. Can I turn to bankruptcy issues in respect of overturned convictions? As we indicated in our previous note on bankruptcy on the 16th of January of this year, Post Office and relevant stakeholders had resolved the key issue affecting compensation payments. That was in relation to Moore. Those were resolved in a way which is consistent with Catherine Alley Casey's opinion on the basis that compensation didn't vest in the bankruptcy estate, and that enabled compensation payments to be made to the claimants in that group. Of the 16 claimants identified by Post Office as having potential insolvency-related issues, 14 have brought non-pecuniary claims and received offers. 13 of those have been settled and paid. One has been settled in principle but not yet paid. The remaining 2 claimants who fall into this category, who haven't yet brought non-pecuniary claims, have both been paid interim payments, with appropriate waivers being given in each case by the trustees in bankruptcy. There is no suggestion that similar waivers won't be available in respect of forthcoming non-pecuniary settlements once reached. No claimants with bankruptcy issues have yet settled their pecuniary claims. There's one case in which Post Office is waiting receipt of a waiver from the official receiver in respect of a settlement offer, but Post Office does not regard that as an insolvency an insolvency issue per se, and doesn't seek to trouble you, sir, on that matter. It's seeking to resolve the issue. If and when it becomes clear that there is an insolvency issue concerned or bankruptcy, we will inform you and seek to resolve the matter as soon as possible. But we'll keep you, as it were, up to date if anything changes in respect of that single case. We note the invitation of Hudgell solicitors, paragraph 8, to confirm in advance that we will meet an agreement that has already been made to reimburse the claimants who had their bankruptcy cases with Moores as part of their pecuniary loss claims. Post Office has no reason to depart from what it's already agreed with Hudgell solicitors. It encourages those claimants to claim reimbursements when they're making the claims for pecuniary losses. Finally, for completeness, when addressing the submissions made by other core participants, I'd note that Post Office doesn't intend to engage in this forum with the submissions made by Hodge, Jones and Allen, which are based on communications and discussions which are subject to confidentiality, and we say ought not to have been referred to on an open basis in written submissions. Now, the inquiry is aware, as we've updated you on several occasions, considerable progress has been made in resolving part or all of the claims from a number of postmasters with overturned convictions on a confidential basis, including through negotiation, mediation, and the early neutral evaluation process. All of those processes depend on the very well-established principle of confidentiality applicable in all alternative dispute resolution processes, designed to enable the parties to resolve disputes without recourse to the courts. We say breaches of confidentiality are highly regrettable and not in the interests of any party. So can I turn then to the issues of taxation, a slightly shorter issue than I might have anticipated. Can I make it clear, Post Office has always been live to the concerns raised about the tax treatment of some recipients of payments and had been working closely with DBT and supporting them in its discussions with His Majesty's Revenue and Customs as to whether the tax treatment of the shortfall scheme could be approved. So we entirely agree that in the light of the indication given by the Department this morning, it's not necessarily to give a full tutorial on the tax regime applicable and why it might differ between the shortfall scheme and overturned convictions. But it may be helpful just to note, sir, for your understanding, the rationale, which comes down to timing. So compensation paid under the shortfall scheme since 2020 has been awarded on a gross basis. Now, it isn't entirely on a tax-free basis because sometimes the Post Office is required by tax legislation to withhold tax. For example, compensation relating to earnings from an office holding, it's required to withhold it on a POI basis. So it isn't as straightforward as saying on every case it's paid out gross. And of course, equally, there are some elements of compensation where no tax will be payable in due course, such as compensation for personal injury, damages and distress.
Sure.
So it's slightly more complicated, but I don't invite you, sir, to get into the weeds of it because the reason why it's different in relation to the shortfall scheme and the overturned convictions is that when the shortfall scheme was set up, paying out on the gross basis, save where it was required to do otherwise, meant that payments could be made much more swiftly. Because if they had been looked at individually according to the tax position of each individual applicant, that would have created an inherent delay in getting the offers out and the payments made. The difference is that postmasters with overturned convictions, those payments are subject to an announcement made in September of last year, which was subsequently legislated to give effect to it, whereby they would be exempt from income tax, capital gains tax, and a number of other provisions. That was made with retrospective effect from the 22nd of July 2021. And that date is after a large number of interim payments had been made, but shortly before the first agreed settlements in relation to non-pecuniary loss had been entered into. So you may remember this is the period in which the early neutral evaluation process was ongoing, and very soon after that, that process unlocked the ability to make offers and they to be accepted in relation to non-pecuniary claims. So the reason that the exemption was capable of being made in relation to the overturned convictions was that there's no need to go back and unpick or revisit the tax treatment of those payments because of the timing of when those payments were offered and made. So that's why historically there is a key difference. But we don't say that, so you need to trouble yourself other than perhaps putting your mind at rest that there is a rationale for it. But Post Office welcomes the Department's indication that it will support Post Office with funding to make additional payments to postmasters in the shortfall scheme to ensure that their compensation is not unduly lost to tax and we await formal advice from government as exactly how it's intended that we do that.
It's nothing as formal as a direction, but I would, simply for my own peace of mind, encourage Mr. Chapman and yourself to persuade your client that when the department makes a formal announcement about this, it either at the same time has a fuller explanatory note that might otherwise be the case, or is prepared to write to me to explain to me the basis for what it is doing. Because I don't want to prolong today's hearing with esoteric topics, but the relationship between taxation and compensation I find quite difficult. And it would help if I had in writing precisely what it is you're both seeking to achieve.
We can assure you what we're seeking to achieve is that no postmaster suffers as a result of the tax treatment.
I understand that Mr. Chapman and I agreed the end point. It's just the route to the end point, or the posts along the route, that I need a bit of educating about.
And we certainly need that guidance or indication or direction, however it wants characterised as well, in order that we can implement what the department is proposing. So,
yeah.
I think on this, so we're in the same shoes.
Good.
So then, may I briefly give a progress update on the shortfall scheme itself?
Yeah.
At the last hearing, so in December, I explained that Post Office was expected to meet its target of making offers of 95% of eligible applications by the end of that day. That was ahead of its self-imposed deadline by the end of the year. It did, in fact, meet them that day, in fact, shortly after I'd finished speaking, but I don't seek to identify any causal relationship between that. It has now made offers in more than 99% of eligible in-time applications. And as of the point that I'm speaking now, this morning, that is 2,396 offers in total. So there are just 21 cases remaining. And those cases each involve specific complexities. The Post Office is working through them, balancing speed with the overarching principle of full and fair compensation. But very significant progress, sir, has been made since we last updated you. And the offers that Post Office has made represent a combined value of approximately £97.8 million, including interest and the deduction of withheld tax. Now, out of the offers which have been made, 1,979 applicants have accepted offers in settlement. That's approximately 83%. And 1979.
Yeah.
And payments have been made in 1,940 cases, approximately 81%. So the total payments, including interim payments, now reach approximately 63.3 million. Now, we note the concerns raised by Howe & Co about delays in the operation of the scheme. We fully acknowledge that it has taken longer than expected and indeed hoped to make some offers, and we expressly and unequivocally apologise for those delays. The Post Office is taking all steps available to progress the outstanding claims. In the just under 1% of claims remaining outstanding, the reason offers haven't been made is because they were awaiting information from third parties, from applicants, or the determination of the final case assessment principles that I'll come on to on particularly difficult and sensitive issues. May help, so you referred earlier to the dispute resolution procedure under which issues which are not agreed can be resolved. Now, in relation to applicants who didn't initially accept their offer, there have been 410 of these, including queries rather than objections. 128 applicants have subsequently accepted it. And of those, 82 accepted it before any good faith meeting, which, so you'll remember, is the first stage in that process. 41 have accepted it after a good faith meeting but before an escalation meeting. And of the 14 cases that have proceeded to an escalation meeting to date, 4 have accepted the offer thereafter, 3 have asked to proceed to mediation, and following mediation, 1 applicant has accepted the offer. And a total of 282 further cases are currently being actively supported through the shortfall scheme dispute resolution procedure by the dedicated dispute resolution team. Now, that team continues to work to schedule good faith meetings as quickly as possible. In some cases, such a meeting has not yet occurred, and this can be for a number of reasons. Now, of the cases that haven't yet got to the good faith meeting by within 100 days of the offer, approximately 30% of those applicants have declined or cancelled good faith meetings or not responded to invitations. Approximately another 30% have had their case reassessed by the Independent Advisory Board rather than go to the good faith meeting as further information has been supplied which might result in a revised offer. The remaining cases, the remaining third, have been delayed where an applicant wishes to source further evidence or where a response is awaited from applicant solicitors. The dispute resolution team hasn't declined any good faith meetings request to date, and as I've indicated, sometimes it isn't actually necessary as a dispute is resolved before that stage. Can I move to interim payments? A matter on which, so we've updated you previously, but the ability to request an interim payment has now been specifically drawn to the attention of any applicants who entered the scheme's dispute resolution process. And to date, 215 interim payments have been requested, and that includes those which we previously referred to as being hardship payments. Of that 215, 193 payments have been paid, representing a total value of approximately £7.67 million. Can I move on to the topic of legal assistance? Since the 10th of October 2022, when, sir, you'll recall the arrangements changed, the Post Office has received 290 requests to pay legal fees. It's sought to work through those requests as quickly as it can in order to avoid delay in progressing applications. It's made payments to applicants in 229 cases. A further 61 offers are awaiting approval of payment. Post Office listened to the feedback from a claimant firm that there were different governance paths to follow between the shortfall scheme and the GLO scheme for approving legal costs, which they suggested was inefficient and time-consuming. We recognise the need for a fair and consistent approach to assessing legal and professional costs, and as such, it's now modified the shortfall scheme cost assessment process. And representatives of applicants to the shortfall scheme were informed of these changes on the 25th of April, earlier this week. The shortfall scheme cost allowances now broadly align with those published for the GLO scheme, and representatives are required to self-certify the allowance applicable to their client's case. Now, the result is a more streamlined process, enabling cases to progress through dispute resolution without undue delay, and we say providing an improved journey for applicants. It's hoped that this more streamlined process will address the delays in obtaining expert evidence that have been referred to by Howe & Co. in their written submissions. For your notes, paragraphs 97 to 100. We also note the submissions made by Howe & Co., paragraphs 43 to 46, in relation to multiple causes of action. Now, we wish to reassure all postmasters we are alive to the issues identified in relation to multiple causes of action by Ms Addy in her opinion at paragraph 37, and to emphasise that each case is assessed and managed in accordance with the principles that she has identified. As such, we don't consider that it would advance or assist matters further by providing the schedule of claimants with potential multiple causes of actions requested by Howe & Co. Can I turn then to late applicants, that is, applications by postmasters who submitted their applications after the 27th of November 2020 deadline. Post Office carefully listened to and considered your comments following and during the hearing on the 8th of December 2022, and in particular acknowledges your statement in the interim statement of 9th of January of this year that fairness now demands an unequivocal statement to the effect that all applications received by Post Office but made after the 27th of November 2020 will be accepted into the shortfall scheme, provided other eligibility criteria are met. We have now made the unequivocal statement, sir, that you asked for. On the 2nd of March of this year, Post Office and the Department agreed that late applicants will not be required to provide a reason for the late submission of the application. The decision was put into effect immediately. The website was updated on the same day to remove the requirement to provide a reason, and the question and answer document was equally updated for new applicants. We have ceased, therefore, asking late applicants to provide reasons and evidence, and we wish to make it clear that no application has been or will be rejected because it was not brought by the original November 2020 deadline. Post Office is in discussions with the Department about the time at which the shortfall scheme will in due course close, but it can confirm this will be no earlier than the 31st of March 2024.
Well, it may assist you to know that I certainly don't think it inappropriate for there to be an end date.
That's very helpful indication, sir. Thank you.
I don't think this could be open-ended, all right?
No.
So I will, on this issue, allow you to discuss an appropriate end date.
I'm grateful. But at the moment, we can say it will be no earlier than the date of the end of March 2024. And I can also indicate that as soon as that date is agreed, that will be published on the relevant page of the Post Office's website. But we reiterate that we encourage all applicants who are eligible under the shortfall scheme to come forward and submit their applications as soon as possible. So just in terms of progress update on those late applications we've received to date, 263 have been received, of which 242 have been assessed for eligibility and 214 found to be eligible. 27 found not to be eligible, but none of those were due to reasons of lateness. There's an outstanding query in relation to one application that's yet to be determined, and there are 21 yet to be assessed at all. 27 offers have been made, totalling just over £350,000. 13 payments have been made, totalling approximately £84,000. Post Office is committed to achieving an effective resolution of all of these cases, again, as you indicated, sir, balancing speed with the overarching principle of fair and full compensation.
I'm smiling, Miss Calliford, because I think on every occasion that you've written since I used that phrase and addressed me, you've reminded me of it.
I hope usefully rather than otherwise, but we're grateful for that characterisation, sir. Can I move on to a slightly different cohort in relation to prosecuted but not convicted? Now, that's a category of applications that has some pretty case-specific complexities, and it has taken longer to proceed to issue offers in that category. Those are potential instances of prosecution but not conviction, or the issue of a caution by Post Office, or in some cases by the police, in lieu of prosecution. Now, we addressed the status of this applicants in our submissions at the last hearing. We acknowledge that the progress of these applications has not proceeded as quickly as it had hoped. In the majority, we've had to undertake additional investigations to determine, firstly, whether or not a prosecution had in fact been commenced or a caution issued in lieu of prosecution, and secondly, what matters the prosecution or the caution related to. In other words, whether it was or wasn't the prosecution or caution relating to a horizon shortfall, or whether it was in relation to some other matter.
And I remind myself, I think, that this category of cases excludes those prosecuted but acquitted who were members of the GLO,
Yes.
where you would have had much more information, in all probability.
Exactly.
Yeah.
Exactly. So in some cases, we've had to send requests for further information to potentially affected postmasters, but based in part on the findings in the earlier neutral evaluation regarding non-pecuniary losses of postmasters who were prosecuted and convicted. That's, of course, in late July 2020 that we've had that. And following the completion of additional investigations, The Independent Advisory Panel has determined a fair approach to compensating shortfall scheme applicants who were prosecuted and not convicted or cautioned in relation to what the panel has determined to be horizon shortfalls. We have duly proceeded to make offers to 17 of these applicants. Can I turn then to the progress update on overturned convictions? Again, we say we have worked hard to deliver both interim and final payments in respect of the claims we've received to date. But can I take the opportunity, at the risk of repeating myself on every occasion, to reiterate the importance of all potential claimants coming forward to bring claims and submit schedules of loss. We encourage all claimants and potential claimants to do so as soon as they're able to.
How many firms of solicitors are you actually dealing with in that, we'll call it a scheme, for want of a better word at the moment?
The last I was aware of, it was 5, sir, but it might now be 6. But again, I'm sure someone can correct me if it's changed since the last time I was advised of that.
Yeah. And are there any, in inverted commas, litigants in person in that scheme?
So I believe there is one, and I'll come on to deal with the position of that individual, but they had been encouraged, you may recall from last time, they had been encouraged to seek legal advice and assistance. So far then of interim payments, so there are 84 convictions that to date have been overturned on appeal, so you may be aware that there are 2 that are in the Court of Appeal today. They're not being contested, so that will go up as of today to 86. But of the 84, as of earlier this morning, the applications for initial interim payments have been made in 83 cases. The one remaining claimant is a deceased estate who doesn't wish to make an application for an interim payment. They have been offered, accepted and paid in 80 of those cases. No further applications have been declined. I'm putting aside for a moment the 3, what we've referred to as public interest only cases. As we indicated in December, following the increase in the value of interim payments up to £163,000 in the light of Lord Dyson's early neutral evaluation, all claimants who were not going to be able to lodge non-pecuniary claims by December 2022 would be offered a top-up interim payment of up to £63,000. We've made offers to 31 such claimants, and to date, 29 of them have accepted those offers and received that top-up payment. The remaining 2 have not yet accepted offers that were made to them in December 22. So far as settlements are concerned, the position is as follows. Post Office has received non-pecuniary claims from a total of 69 claimants with overturned convictions and made offers in respect of 67 of those claims, 55 of which have been accepted. So that's non-pecuniary. So far as pecuniary claims are concerned, we've received claims from a total of 14 claimants, 11 of which have been fully particularised, the others not fully particularised. We have reached full and final settlement in respect of 4 claims, including 2 of the 3 public interest only cases. We've made offers in respect of 4 of the 6 claims received by mid-2022, together with offers of further interim payments where appropriate. The remaining 3 claims, this is the pecuniary claims, were received last month in March 2023. Post Office is in the process of reviewing them and will endeavour to make offers in relation to those claims as soon as possible. Now, in total, Post Office has paid over £18.5 million in compensation to postmasters with overturned convictions since August 2021. As I've already flagged up, following a process of independent mediation, full and final settlements have been reached with 2 of the 3 public interest only claimants, both represented by Hudgell solicitors. As yet, Post Office has been unable to agree a settlement with the remaining public interest only claimant who participated in the mediation. Can I move on then to the question of pecuniary claims and contingency planning? So Post Office has carefully considered the observations you made in relation to the need for contingency planning for disputes about final compensation payments that cannot be resolved by negotiated settlements. That was flagged up in your original progress update from August of last year, reiterated in your statement of January of this year. Now, we hope at least to some extent, address your concerns. Post Office has been in active discussions with claimant representatives as to the best way to approach the assessment of compensation for those losses. And in particular, on the 31st of March of this year, Post Office shared without prejudice on a confidential basis proposals with claimant representatives relating to a new process for managing claims by those with overturned convictions. And those proposals concern both the first of two tranches of suggested principles to help determine the value of pecuniary losses, and secondly, a suggested new process for handling such claims, which includes an option for an independent assessor to make a recommendation in respect of any aspect of a claim which cannot be resolved consensually. Now, Post Office is currently consulting with claimant representatives in relation to these proposals. It hopes that these proposals will make it simpler for claimants to present their claims and allow Post Office to make full and fair offers of compensation more quickly. You'll have indicated I said that the first tranche of principles had been sent through. We intend to send the second tranche of principles, which is 55 out of 16 of the principles to be included. Those tranche of principles also to help determine pecuniary losses. We intend to send those through next week. They're just going through the final stages of the Post Office governance process. Again, those principles are open for consultation and responses by core participant and all claimant representatives about the principles. Now, we have reaffirmed to claimant representatives our commitment to paying the claimants reasonable costs of participating in the new process, and that includes the process of considering and commenting on the proposed principles and process. That's to be assessed on a standard basis if not agreed. Now, we acknowledge that the work to design and consult on this process has taken some time, but our hope and expectation is that that initial investment of time will increase the rate at which claims come forward. As I've indicated, it's only 14 to date, and in which then offers can be made in respect of pecuniary claims, and also will provide claimants with a greater degree of transparency as to how Post Office intends to approach issues relating to compensation, and that, of course, we hope will also help achieve consistency in levels of compensation offered. It will also, we hope, establish useful and agreed arrangements for independent third-party resolution of disputes arising in the course of such assessments. To ensure that the introduction of this process doesn't cause any delay, though, Post Office will and has been continuing to make offers and consider offers in relation to pecuniary claims that have already been received, and will continue to do that on any that are received during this consultation period. It emphatically doesn't want the introduction of this process and these principles to delay potential claimants coming forward and submitting their claims now. So we're very happy to provide an update on those principles and that process if it will be of assistance once the consultation period has ended and that we have drafted them, taking into account those comments. But I leave that, Sarah, in your and the inquiry team's hands. But as I've indicated in respect of any of these matters, we're happy to update, but it does seem to me and Post Office that that's a matter upon which you'd welcome some further information in due course. Can I move then to a slightly separate topic of prosecution-related payments? So these are cases where claimants have been subject to financial recovery measures either by Post Office or His Majesty's Court Services in the course of criminal proceedings against them. Now, our understanding is that up to 67 of the overturned conviction claimants were subject to such measures. Now, that's either because they proactively repaid claims said to be owing in the hope of avoiding prosecution or receiving a lesser sentence, or because a formal confiscation or compensation order was made against them in the context of a criminal trial. Now, we had originally intended to repay these sums at the same time that it processed and settled pecuniary claims, but given the relatively small number of pecuniary claims received to date, we've now commenced a more proactive process to do this. Now, Post Office, through its solicitors, has analysed the historical Post Office and third-party records to identify and quantify the amounts actually recovered, so as to enable Post Office, where possible, to commence proactive repayments of these amounts, which will be made together with compound interest at 3.45%. That is in advance of receiving particularised pecuniary claims. That's subject to one somewhat technical caveat, which is confiscation orders paid through HM court service and tribunal service rather than directly to post office are required at the request of the court service to be recovered through them rather than through post office. But post office will proactively assist affected claimants with that process.
So, again, just so that I can get the picture, if a postmaster voluntarily paid £20,000 either to try and avoid a prosecution or to, as you say, help with sentence, post office themselves can activate whatever needs to be done in order to repay the sum.
Yes.
If, however, the postmaster was subject to a confiscation order by the court, there has to be a different process through the court. Is that
Exactly, exactly. But we will assist with that process that needs to be gone through. That's at the request of the courts and tribunal service, and we can assist with that. So as of today, 16 offers have been communicated in relation to such payments, and 2 have been accepted and paid. So where Horizon-related shortfalls were paid directly to Post Office, the number of offers or settlements are 23 out of a potential 39. We will continue to review our records and will make further offers in due course if that's possible. Can I just deal with 2 other short matters? The first is in relation to potential future appellants. Now, so you may recall, in our submissions for the previous compensation hearing, we set out the considerable efforts that Post Office and the CCRC had been taking to ensure that all convicted postmasters are contacted and encouraged to consider their options for appeal. That included, you may recall, most recently setting up a dedicated phone line and a microsite in collaboration with Citizens Advice, so that postmasters who felt uncomfortable interacting with Post Office or otherwise wished to seek independent advice could do so. However, as of today's date, of 700, that's the figure, so which, following further investigations, we believe to be the number of potentially Horizon-related prosecutions during the relevant period, of 700, only 159 individuals have brought an appeal or applied to the CCRC. That leaves 541 who are yet to appeal, were they to wish to do so. Now,
and without committing you to what might happen in any appeals, when you use the phrase 700 Horizon-related convictions, do I understand that those are convictions which you accept potentially might give rise to a ground of appeal?
I'm going to come on to exactly that point, sir. Those are cases in which Horizon had some role.
Right.
And what Post Office has done to take an even more proactive approach is that it has decided that it should determine whether it already holds sufficient material to reach a view that an individual's case could properly be conceded as a Horizon case, as set out by the Court of Appeal in Hamilton and others, were an appeal to be brought. Now, the decision, of course, as to whether or not a conviction should be overturned remains that of the appropriate appeal court. But that process is now in place. It's being administered by the Post Office's external criminal lawyers. And the process is that cases are initially reviewed by independent junior counsel, and then King's Counsel will provide Post Office with formal advice on whether, on the papers available currently to Post Office, the case could reasonably be conceded by Post Office if an appeal were to be received.
And then what?
And then, in respect of appeals and cases where the appeal lies to the appropriate appeal court, Post Office intends to contact those individuals to notify them it would not oppose any future appeal on the basis of the information that it currently holds, and it will set out what to do next. For cases where the necessary route is via the CCRC, Post Office is in discussions with the CCRC as to what approach should be taken, how that route should be followed. Now, in terms of the progress that's already been achieved to date in relation to this process, Junior Counsel have already reviewed the vast majority of cases of the 541, where no appeal or application to the CCRC has been brought, and King's Counsel are in the process of drafting their advices. Post Office's Remediation Committee has delegated board authority to deal with criminal appeals, and it will shortly consider the first cases that Senior Counsel has identified as cases that could properly and reasonably be conceded were an appeal to be brought. And it's anticipated that letters will be sent to this first tranche of individuals in May or June of this year. We are continuing to review options in relation to those cases where it has been impossible to identify as a case that Post Office could reasonably concede it. So there are obviously going to be a number of cases and where the material before Post Office at the moment doesn't mean that it's in a position to say that they would reasonably be conceded. Now, this initiative goes beyond Post Office's legal duties of post-conviction disclosure, but I make it clear Post Office wishes to take every step to ensure that no miscarriage of justice is missed. And so we'll obviously continue to update you in relation to this exercise in due course. Finally, can I deal with the GLO compensation scheme? Firstly, it might not be quite finally, pre-finally, firstly in relation to that scheme, we welcome the announcement of 23rd of March that the GLO compensation scheme is now open for applications. We further welcome the statement yesterday that the scheme's guidance and principles will be amended to make it clear to postmasters that the guidance is not prescriptive, the facts of each case will be looked at in the round, and all decisions guided by considerations of fairness. We note that since 2021, Post Office has encouraged and supported the commencement of such a compensation scheme, and indeed, on the 25th of May of that year, the then chairman of the Post Office, Tim Parker, wrote to the then Parliamentary Under-Secretary of State for then Bays, proposing options for further and more fulsome compensation for postmasters. Post Office has been collaborating and cooperating fully with the department on matters of disclosure to support the scheme. It is using all resources available to it to collate disclosure for that scheme. But I would emphasise that the gathering of the data to support these claims does require a detailed and technical knowledge of Horizon and other Post Office systems, meaning that specialist personnel within Post Office are required. Now, we note the concerns raised on behalf of postmasters, both by Howe & Co and Freeths, and indeed concerns, sir, that you have reiterated this morning in relation to the time frame for disclosure. We would wish to emphasise that the indicative time frame of 32 weeks is for the total delivery of the project. We will aim to provide a regular output of disclosure once applications are formally received by Post Office from the department. In other words, the indicative time is not how long each application will take, it's the long stop anticipated currently for all of them. We emphasise, though, delivery of disclosure is subject to a number of external factors: receipt of complete applications and application volumes, paired with the availability of appropriately experienced and skilled staff. The time frame for the provision of this disclosure is under constant review by Post Office. We fully aim to provide the service to the department in order to support the GLO scheme as soon as reasonably practicable. We continue in the meantime to service all urgent applications from the department relating to any form of hardship to avoid any delay.
And for these purposes, I accept what you tell me, Ms. Gallifant, but even on the basis of the rolling programme, which of course I fully accept will occur, inevitably it's going to be virtually the end of the year before some documents relating to some applicants surface.
So I'd accept that.
And so I keep banging on about it, to use that phrase, but that leaves 8 months next year.
Yeah, so we entirely accept that, and we are using all best endeavours. Finally, sir, and I promise this is actually finally, can I just emphasise that Post Office fully recognise that although today's hearing concerns compensation, money is not the only form of redress that Post Office could or should offer. And Post Office is listening to the calls for restorative justice similar to the processes agreed in Windrush and the Grenfell Tower civil litigation recently. It will work closely with the department to consider how best it can assist with any restorative justice proposal. Now, during Post Office's opening submissions in October of last year, Post Office invited any postmaster who'd like to meet a senior member of Post Office and receive a personal apology to contact Post Office for that to be arranged. So far, 6 meetings have either occurred or have been scheduled. Both the Chief Executive Officer of Post Office, Mr. Reid, who sits to my right, and the Chair, Mr. Staunton, who sits behind me, are present today, and both take this issue very seriously. On behalf of Post Office, I renew the invitation, which is made in good faith and a genuine desire to listen to those affected by the scandal and to apologise for it. And I would encourage all postmasters to consider it. Thank you, sir. I'm conscious that I've overrun my time, but I hope that was helpful.
All right. Don't worry about overrunning, Ms. Gallifant. I've been listening carefully to what both you and Mr. Chapman have had to say. I think everyone knows that for my convenience, I want to take lunch at 12 o'clock today, not 1 o'clock. And we're almost there, so I'm not going to ask anybody to speak before lunch. So can we start again at 1:10? Is that all right? Fine, good.